Hearing now, the Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Welcome to the first call of the new year. For those of you who are not frequently with us, there are a few things that I usually discuss so that the council will understand. We, for the calendar cases, they're 30 minutes per side, and the first 5 minutes of which are given to you free of questioning so that you can discuss the outcome determinative issues, and we encourage you to do just that. We've read your briefs. We don't need a recitation of the facts unless they're critical to the outcome determinative issues that you wish to raise. And so with that, I'll call the first case, Rock versus Crocker.
May it please the court, on behalf of Dr. Thomas Crocker and his PC, I do plan to reserve 10 minutes for rebuttal, though I understand that that's my obligation to keep track of. I do want to spend just a few minutes talking about the first issue in our brief, that is the admissibility of standard of care testimony on alleged breaches of the standard of care that aren't connected to the plaintiff's injury. There are two problematic statements in the Court of Appeals opinion. The first is that those types of breaches, quote, may be relevant to the jury's understanding of the case. And the second is even more unequivocal, that each breach is relevant to the defendant's competency. Competency isn't an issue in medical malpractice cases. Competency is a question for regulatory and licensing matters that don't require a connection to an injury. Medical malpractice cases focus on duty, breach, causation, and damages. Juries don't award damages based on a general assessment of competence because even the most incompetent doctor could have not breached the standard of care. And even the most highly skilled and competent doctor could have breached the standard of care. So in medical malpractice cases like this, the jury needs to focus on the claims that are at issue, and the plaintiffs in this case have admitted that the two alleged breaches concerning the screw and plate placement and the weight-bearing claims are not at issue. I think the University of Michigan Board of Regents filed an amicus brief that effectively explained the concern with the Court of Appeals statements in that it encourages a shotgun approach in which issues that aren't really at issue will be litigated even though the parties concede that they didn't actually cause an injury. And there's also a second part of that where the defendants will then want to respond with all the evidence concerning other times that they have met the standard of care. In cases like medical malpractice that are exceptionally complex and already involve loads of time, it's an undue burden to add that to the jury's concern and to the litigants. For our second issue, we're asking this court to apply the statute as written and hold that when a doctor, the defendant, is board certified, the expert must be board certified when he testifies. I'll waive the remainder of my 5 minutes and answer any questions.
Counsel, good morning. I just want to jump right in because the question I have is that in dealing with the weight bearing and in dealing with the screws being placed the way that they were, it all arose out of the same course of treatment. It all arose out of the same transaction. So help me to understand better why that wouldn't be relevant.
Well, it wouldn't be relevant. And to clarify, our position isn't that the jury can't hear about the plate that was inserted or the screws that were inserted, how they were inserted, things like that. What they can't hear and what becomes confusing and the courts exclude and must exclude is the opinion that those things that didn't cause an injury, that have nothing to do with the injury that's at issue in this case, breach the standard of care and invite the jury to make an inference based upon an unconnected breach of the standard of care.
I guess my question back to you is, your argument that's unconnected, but it still arises from the same types of care. It still arises out of the conduct and care under the initial transaction, does it not?
It does. This is definitely within the course and scope of treating Mr. Rock's injury. I guess a good way to explain this is, first of all, so the weight bearing, for example, that's a post-surgical treatment decision that doesn't really reflect at all on what Dr. Crocker did during the surgery, right? That doesn't indicate that he doesn't know what he's doing during the surgery. It suggests maybe he doesn't know something about post-surgical care. So that's not connected to what they're actually talking about. And in terms of the screw and plate placement claim, I think the important point to understand for that is the injury at issue here is a trimalleolar fracture. So there are 3 bone areas at issue. And what the plaintiff has conceded is that the screw and plates that were inserted to fix the lateral malleolus bone, which is the bottom of the fibula, they've conceded that that didn't actually cause the injury, because what they're talking about is the fracture of the medial malleolus. So it's a different bone, it's a different part of the ankle that was fractured, and the screw and the plate that was inserted on the lateral malleolus has nothing to do with how to treat and fix the medial malleolus. That's why they've conceded that that isn't involved in the causative link.
Help me if I'm wrong, but I thought your primary problem with this evidence was not that it's not logically relevant as per 401, 402, but that it's not legally relevant and permissible as per 404B, because it's other acts evidence which doesn't meet any of the exceptions for when that's permissible. Am I?
I guess my argument on that would be in the alternative. First, when there isn't a link, when you have an alleged breach in the standard of care that has no link, I don't think it's relevant. I don't think
logically relevant, even though, as Justice Bernstein saes, like that it's all one, transaction, right. And the logical relevance feels like a harder burden for you. I mean, why do you need that if you have a good 404B argument? I
appreciate that. Maybe in a different types of cases.
You like to do it the hard way.
Sorry.
You like to do it the hard way.
If at all possible. I do appreciate that in certain cases there could be. And certainly the surgical procedure is, I think, probably closer to the mark. The weight bearing is entirely separate. Like I said, it's a post-treatment type recommendation. Mm-hmm. The surgical, maybe in the right case, you're talking about.
There's so much that is logically relevant.
It's a big window of logical relevance.
I mean,
sure.
That's why we need 404B.
That's exactly right.
Well, okay. But 404B is then, I guess, the next step. And I think it also contemplates
it might be the first step for you.
Or the fourth step. We can jump over 402 if you'd like. The 404B, when you get there, what they're talking about and what this court has said over hundreds of years is that this type of evidence, where you're saying because he did something wrong here, then he must have done something wrong there. It's an improper inference. And that's the only suggestion that the trial court and the Court of Appeals have given to this point for how this evidence might be used. They're saying this might be used to show that this is a doctor who doesn't know what he's doing, or he's a bad doctor, so he made other mistakes, so he must have made a mistake here. And for over 100 years, this court has said, we don't let juries get into the morass of making that inference because, like I said earlier, you can be maybe not the greatest doctor in the world. That doesn't mean that you breach the standard of care in the way that the plaintiff alleges, and it deters the jury from focusing on exactly what the doctor did that the plaintiff does claim breached the standard of care.
Well, let me ask you a nitpicky question about the 404B piece of it. From what I can tell, the trial court and the Court of Appeals didn't really cleanly address 404B. Was it preserved? Did you argue 404B in the trial court or the Court of Appeals?
404B wasn't.
Does it matter?
No, and here's why. 404B wasn't raised in the motion in limine that was filed in the trial court. What was raised was 402 and 403. Mm-hmm. And the reason 404B, I think, sprung out of that is twofold. It's first, the court's opinions, what they said in their opinions directly implicates 404B. And the concern, I think, for this court is that that's in a published opinion now. And if the analysis is wrong under 404B, it needs to be corrected.
Wait, so you're conceding that you didn't raise 404B in the trial court?
Specifically in the trial court, we didn't. What we raised was 401, 402, and 403. And the second part of my answer to that is the reason that you can still reach this and that shouldn't be a concern is I think and I think People versus Vanderbilt spoke to this, particularly in a footnote, is that if you apply 402 and 403, the answer you'll get to is 404B. 404B is basically a shorthand summary addressing particular type of evidence that frequently comes up and giving the answer to how that evidence can and cannot be used. So if you're applying 403, the undue prejudice, confusion of the jury, that's the answer you should get to.
Well, so even if we thought that was right, there are exceptions to 404B. So let's assume that we think you've properly preserved it in the trial court. Shouldn't we then remand to allow the trial court to consider whether any exceptions to 404B might be relevant?
No, because none have been articulated.
Well, right, but that's
But you
because you
didn't
didn't raise it in the trial court.
It's true, but...
Well, let me just
Yeah.
say, in response to the motion in limine, plaintiff argued the defendant's, quote, attempted repair of the fibular side of the trimalleolar fracture.
I'd love to see you struggle with a word.
Yeah, thank you. Dyslexia is a wonderful thing. Was below the standard of care. Even though it did not cause any damage, it goes to defendant's credibility as a physician, and it tends to make the existence of his malpractice more probable than it would be without this evidence. That is a propensity argument.
That is.
Yeah. Well, I mean, that was what they said in response, and still that didn't trigger 404B.
Well, so we filed the motion in limine, raising 402, 403. The plaintiffs filed their response, and the court decided it on a written opinion. So there was no then response to what they had said. And what the trial court did was pick up and give a propensity rationale for allowing the evidence in.
And when did you first raise the 404B issue?
I believe it was in the Court of Appeals brief.
Okay, in response then to the decision on the 4043?
Right. And again...
I would like you to run through the traces again, explaining why your failure to raise the 404B argument that is front and center now is not waived.
Because 403 should get you to the same place anyways.
Yeah, but no, not necessarily.
And we raised 403.
404B articulates, in effect, an exception to logical relevancy.
Okay.
So unless this was extraordinarily prejudicial, another kind of analysis entirely, I don't see why they are necessarily linked.
But it's what you just said in terms of unless it's extraordinarily prejudicial. And that's the 403 analysis.
I mean, the policy of 404B is, yes, that we declare this propensity kind of evidence to be, which is logically relevant, to be too prejudicial. But
Right.
that's not necessarily the same analysis you conduct under 4043 without interposing the policy judgment of 404B.
That is the same type of analysis.
It's a higher burden, though, for you. 403, we have to find it's, far more prejudicial than probative. Under 404B, we say propensity evidence is more prejudicial than probative. And it's
Right.
only permitted for these specific purposes. Why don't you like the easier path?
No.
He's got a problem because I think
Right.
there's a waiver problem.
I don't know that it's waiver at this point. It's a motion in limine, right, that was raised before trial to address this evidentiary issue. Certainly could still be raised during the trial. The concern, I think, that has come up at this point is the trial court's rationale is directly suggesting that this propensity evidence is admissible for propensity, and the Court of Appeals published opinion suggests the exact same thing.
Okay. All right. I think I understand the argument.
Okay.
You want to discuss why Dr. Viviano. Unrelated, I guess. From Macomb County, how can this be? Why Dr. Viviano is disqualified from testifying?
He's disqualified because the statute says if the defendant doctor is board certified, the witness must be board certified. There's no dispute, and actually I checked it yesterday, Dr. Viviano is still not board certified. So under the statute, he cannot testify. And I think the important point in the analysis of that statute is to look at the start of it. That is, the subject is an expert giving expert testimony. And the first statement about that is the expert must be a person who is licensed, which is contextually consistent and pertinent to the board certification requirement. 'Cause it's
Counsel, if I might, I want to propose a hypothetical because I've been thinking about this intensely. So in the fact pattern that we have a person that was board certified at the time of the incident and was not board certified at the time of the trial. So I want to do a hypothetical with you. What if you have a situation where you have like a world-renowned board-certified surgeon, and this person is board-certified at the time of the incident, but then they retire, or they go into consulting, or they leave the practice of that specific specialty because they retire, they get older. Would it then be your perspective, or would it then be your argument that they shouldn't have the opportunity upon retirement to be able to testify?
Yes, and the answer to that is yes, because that's what the statute requires. And I think it's also important that the statute requires board certification. So if that doctor, the world-renowned doctor...
But if you can address the Court of Appeals, though, indicated the statute, indicated a different interpretation. So if you could kind of qualify that based off of the Court of Appeals.
Well, the Court of Appeals is suggesting that it doesn't make sense for a doctor who was board certified, loses his board certification for whatever reason, then can't testify. What I'm suggesting is there are perfectly reasonable policy bases to interpret it to require the board certification, which is a credential much like a license at the time of trial, because it shows that the doctor is still dedicating himself to the medical field. He is still doing the things that are required to maintain that board certification. And if you want to be an expert, this suggests that you want to go out and get a board certification. So it has the policy rationale or support behind of encouraging doctors who want to either continue to practice and sell themselves as board certified to obtain that certification, or who want to market themselves as experts who can give testimony to maintain that board certification.
But counsel, what about all the physicians that, again, go into consulting, or they've retired, or maybe they've assumed some kind of an injury that doesn't allow them to use their hands? Mm-hmm. You're going to basically argue to those physicians that they are no longer really relevant and they can't testify. So aren't you, in a way, preventing a lot of retired physicians or people who can't be surgeons at the time of trial due to some incident that occurs in their life, like they get older or they have, issues with their hands or what have you, and they still have that knowledge, they still have that expertise, and they had it at the time of the incident? Would it then be, again, your argument that those folks should not have the opportunity to testify or consult or be relevant in these kinds of arenas?
My argument isn't necessarily a should or should not. It's based on what the statute is providing. And what I think the statute is providing is that those people should do what they can to maintain that board certification if they intend to continue to try to supplement their income by being experts and giving testimony.
Can I ask you said that board certification is more like licensure than specialty. I thought you only got certified in specialties. Am I misunderstanding?
No, not at all.
So why isn't it more like specialization than licensure?
It's more like a licensure because it is a process through which you go through to obtain a credential. You take tests.
Yeah, but licensure is baseline.
Yeah.
Right. Licensure is baseline. And
this is a specialty above baseline.
Right.
And that's what you're
certified in. So why are you equating the two?
It's equating to showing that you have gone through that additional process of taking tests, taking oral exams to obtain that.
You don't have to be certified to practice medicine.
No, you don't.
But you have to be licensed.
You have to be licensed.
Why are you conflating the two?
I'm comparing the two because I think what the board certification does.
You're trying to confuse us, right?
No, I'm not.
Oh.
What I think the board certification in this context does is when you have a defendant who's board certified, who's going to testify in support of his standard of care and what he did, to give the jury an apples-to-apples comparison, to have someone who has similarly gone through and show the dedication to the medical practice to maintain and go through the process of obtaining and maintaining a board certification, to come in and testify against that person.
What's wrong with the Court of Appeals construction of this statute?
It interprets it is as was when there's no language in the statute to interpret is as was.
So if the defendant in this case had died 1 hour before trial at that point, immediately at that point, Dr. Viviano would have been able to testify. Is that right? Because the defendant no longer would have been qualified as being, with regard to the phrase, is a specialist. He no longer would have been, is a specialist at the time.
No, he would have been because the specialty requirement is locked into the time of the malpractice. I think that's very expressed within that first sentence of subsection A, which says specializes at the time of the occurrence. It is tethering.
But you're suggesting that at the time of the occurrence is not part of the second sentence.
Exactly.
So why would he not, why would Dr. Viviano, who could not have testified an hour before trial, have testified at trial in light of the fact that the defendant no longer would have qualified under the is language, which in the second sentence bears no relationship to the time of the occurrence?
Because at that time, the jury is no longer receiving testimony from a board-certified defendant who then has that certification, that qualification or credential that this statute is suggesting the expert must match. If he dies before, I understand it's an anomalous result, but then the board certification requirement would not apply.
So if they use the video, assuming they deposed the defendant and the defense wanted to use the videotaped testimony of the deceased defendant, that Dr. Viviano would then be able to oppose that because, although deceased, there is testimony.
In terms of a de bene essay deposition, whether or not he's board certified at the time of the testimony.
No, Dr. Viviano lost his certification a long time ago.
Right.
But now the question posed by Justice Markman is, when the defendant is deceased and therefore no longer is,
right, does
your argument collapse when the defense interposes the de bene essay or otherwise videotape testimony of the defendant at trial? Can Dr. Viviano come in and now testify even though he's not board certified because the board certified defendant no longer is?
It's an interesting question that would be based on whether or not the testimony that the defendant gave during his de bene essay deposition is then considered to be given at the time of the de bene essay deposition, even though it's played for the jury at a later time. It's an interesting conceptual question that isn't an issue here. It might come up, and certainly I think courts are equipped to address
We're trying to
that.
figure out how to parse the statute. There seem to be three different actual sort of requirements here. The third talks about the board certification, and it's introduced by. It's a full sentence, introduced by however, right?
Correct.
So that's what I'm struggling with is why the Court of Appeals construction essentially treats the third sentence as though it is a part of the second. Why that's wrong.
It's wrong because they are two separate sentences. There's a shift signaled definitively by the word however. And then there's a return to the same language that's used for the licensing requirement. And again,
but isn't that the same language that's used in the specialization requirement as well?
It is not because
preceding sentence.
Sorry, it is not because the specialization requirement has the modifying phrase "at the time of the occurrence" that is not in the board certification sentence. If that phrase was in the board certification sentence, there's no argument here. But the argument exists because the context is a witness giving testimony.
But it says specializes. I guess you're right. It's not the same language, but it's the same verb tense. Specializes.
It's a verb tense.
And the legislature specifically deleted specialized when it amended the statute. So what we know for sure, I think, is when we look at licensure above, under the old regime, you could have been licensed before or at the time of testimony, right?
Correct.
But the legislature said, nope, we want you to be licensed when you testify. So that's pretty clear, right?
Right.
Same thing was with specialization. You could have specialized at the time or specialized now under the old regime, but under the new regime, it's only specialized at the time of the occurrence, right?
Right.
And so as Justice Young points out, now we're with the board certification, that's an additional requirement, additional to the specialization requirement. Would you agree?
It only comes up if the doctor is specialized. I'll
Yeah,
agree,
it's related,
yes.
pretty closely related, as Justice McCormick mentioned, to specialization, right? It's a further step
It is.
in that direction. It comes in the same provision as specialization in the immediately following sentence. So I guess to repeat the question, why doesn't it make sense to interpret it? And by the way, it uses the same verb tense as the preceding sentence. So
Because
why
it-
wouldn't it make sense to interpret it to mean board specialization in the specialty at the time of the occurrence?
Right, because it uses the same verb tense, but it excludes that modifying phrase, and that makes all the difference.
Well, it doesn't exclude it, it just doesn't repeat it.
Well, it doesn't repeat it. It also starts the sentence with however, signaling a shift, and something that applies in spite of the specialization requirement, which is.
Well, in
this
spite of
quick-
or in
Well, it's not
addition
spite of-
to.
Right, it's not in spite of the specialization requirement, that remains.
It does.
Maybe it's in addition to.
Okay. I mean, it could be in addition to, but that doesn't answer the when question. The when question is definitively answered.
It does answer that if it's in addition to A and in addition to B, then A and B are linked. So that would answer the question.
I'll agree that the board certification is necessarily linked to specialization,
And why not the temporal requirement then of mere specialization?
because the temporal requirement wasn't placed in the board certification
Agreed,
provision.
but the question is whether there is nevertheless a rational reason for believing the legislature intended the two to be linked, not only in terms of the specialization, there's a different level of specialization, but if they are logically linked in that way, why isn't the temporal also linked?
And I see that I'm cutting into my rebuttal time, so I'll answer the question and then reserve the remainder of my time.
Well,
You
no,
could try.
I'd like to cut further into your time, too. But why don't you finish this question, please?
Again, getting back, I guess my point in response to that is that the board certification, though it's linked to the specialization requirement, is akin to a credential much like the license, and when the legislature parrots the same exact language as they did for the licensing requirement, and that was expressly changed when they added the board certification requirement, that signals a legislative intent as to how that provision applies.
Well, speaking about parroting language, the entire Section 1A clearly refers to the time of the occurrence as the proper frame of reference. The first sentence in Section A, 1A, refers to the time of the occurrence as the proper frame of reference.
Expressly.
The entirety of Section 1B, the entirety of Section 1C. Why is it not reasonable to read the second sentence in 1B not as containing a negative pregnant, suggesting that that sentence alone chooses not to refer to the time of the occurrence, but simply in terms of it not choosing to repeat something that's already been made crystal clear by the surrounding context and sentences?
Because they
Why
didn't.
isn't that the more natural way to read that sentence?
I don't think it's the more natural way to read it, because the legislature showed that when they wanted to refer to the past, they knew and expressly did it with that phrase of referring to.
Well,
at
you've
the
read our
time of the
decision in
occurrence.
Robinson, no doubt, in which
I
we
have.
make clear that you don't have to repeat ad nauseum the same term that seems to be implicit in the previous sentence and the subsequent sentence, haven't you?
Yes.
And what is the relevance of Robinson, if any, to this case?
Well, in terms of needing to repeat it, I think here also the fact that it's, again, parroting language from the is licensed is a contextual clue, and the starting this phrase, however, indicating that we're shifting to something different, an additional something different requirement that the other party must meet.
And you know, in addition to the conundrum that I think you have to deal with that might arise where the defendant himself dies an hour before trial, the question I put you a few minutes ago, what about the situation in which in which a pretrial motion is made for summary judgment on the part of the plaintiff to resolve the case on the basis that the defendant's expert cannot testify the defendant raises a pretrial motion for summary judgment on the basis that the expert cannot testify. Wouldn't that, how would you resolve it in that context where, given your premise that the time of the trial is what we focus on, would it be irrelevant that there was a matching of the expertises in a pretrial motion as opposed to at trial because we only look to the trial to determine the proper matching time? What if there was a pretrial motion for summary judgment on the basis that there was an absence of a match? Wouldn't you say that that's irrelevant in terms of a pretrial motion?
In terms of whether or not the plaintiff has the plaintiff's expert has a board certification, if he can't qualify at that time and the plaintiff does not have somebody who's board certified, qualified to testify at the time of trial, then yes, the summary disposition would be granted.
So in other words, there would be a different result produced at trial as opposed to the result that would be produced in the context of a pretrial motion simply because the matching has to occur at the trial?
No, well, in summary disposition, it's at that point the plaintiff needs to be ready to present their case and have the available evidence to show that they can go to a jury. That's the difference with the summary disposition motion. If they don't have that,
I don't understand what you're saying. You're saying the summary disposition motion would be decided on the basis of the status of the expert at the time of the motion itself or at the time of the trial?
It would be decided based on what evidence the plaintiff has at that time.
Wouldn't the response have to be, he will be board certified at the time of trial?
And if the plaintiff can show that his expert will be board certified, then that would be a question.
If you can't show that, then it's...
Yeah, then the summary disposition on that basis would be denied.
Okay, thank you.
Thank you.
Good morning. Mark Ronzato on behalf of the plaintiff appellee. I waive any self-imposed limitation that you may have on the asking of questions, but I would like to begin with what is by far the most significant question in this case, and that's the issue of Dr. Viviano's qualifications.
Let me
MCL.
flip that then.
I'm sorry?
Let me flip that. I'll let you get back to that. I read...
Can I withdraw my waiver? No,
Yeah, you can. Well, I mean,
I'm just kidding. I'm just kidding.
I'll let you, obviously you'll get to the competency issue, but I want to deal with the issue you think is irrelevant or less valuable, and that is what looks to me like a frank acknowledgement that what you want the testimony concerning the plate and weight bearing for is nakedly a propensity reason.
Well,
I just read it to you. Did that not sound like
we are
propensity?
all at a disadvantage, largely because this was not something that was addressed in the trial court.
Do you want me to read it to you again?
Pardon me?
Do you want me to read what your predecessor said?
Well, no, I actually
Isn't
have
that
read it, believe it or not.
Isn't that a naked propensity argument?
Well, the fact is that there are a lot of reasons.
Let me just ask you
Was
real
his
simple.
argument a naked propensity argument?
Yes.
I would grant you that is correct.
No. Okay, that's all I want is an
Okay.
acknowledgement. Now, why do we, in this context, permit propensity evidence to come in?
Well,
What's the non-propensity purpose for which you would have offered it if you were the lawyer in the trial court?
okay. Well, I mean, obviously, the 404B issue, I don't know if it falls under other crimes, wrongs, or acts in light of the question of whether this is, in fact,
It's
a
another
unit.
wrong. Look, if it is, in fact, malpractice or violation of the standard of care, the size of the screws, the size of the plate, advising him to weight bear when he shouldn't, if those aren't other bad acts of medical practice, I don't know what they are. Do you concede that they would be?
Well, we really are at a disadvantage here in light of what has not been done in the lower court. But, for example, let's say
Is my
Dr.
question really that hard?
No, but the fact is,
Well, then answer it.
we are dealing with the court rule.
Answer my question.
Okay.
Are those, in the context of malpractice, a malpractice case, other bad acts?
Well, it's a good question. I don't know. The fact
Okay,
is,
that's fine.
the
Go on
fact
to your
is,
argument.
I don't know if it's an other act. It is the same surgery. He botched this part, and as according to our expert, he got lucky. Now, we are dealing with a court rule, a rule of evidence that has built into it exceptions for any other purpose. Now, the fact is, it's never been explored by the trial court, by the parties.
So are you
But for
arguing-
example,
Let me stop
Okay.
there. Are you now arguing for a remand on a 404B analysis at the trial court?
no, I'm arguing for a waiver of the 404B
But
analysis.
this issue was decided in the Court of Appeals.
Yes, okay. You may be correct on that. I haven't gone back to his brief.
And if it's wrong, we have an obligation to address it. If the analysis, the 404B analysis is wrong in the Court of Appeals, don't we have some obligation to make sure the correct standard is applied?
And it's interlocutory, so once the first motion's up, you can have this motion, so the waiver is really not that strong a position.
Well, I would suggest to you in a situation in which I have a rule of evidence which has built into it exceptions for any other reason, the fact that it wasn't raised in the trial court is a pretty significant problem for the
But it can be,
defendant.
if this case goes back, they can raise the 404B issue, can't they? Unless the Court of Appeals decision creates the wrong legal framework.
Well, I should think if this case, when this case goes back, because it will go back, no matter what happens here, I can't stop them from bringing a 404B motion, right?
So, well, doesn't that answer the question then?
But look, what if Dr. Crocker testifies as he did in his dep? I've done hundreds of these ankle surgeries, okay? That's what he testifies to in his deposition, okay? Now, we have an expert who says nobody with any experience in this trimodial or whatever it's called surgery.
Thank you, I had the same trouble with it.
Yeah, I had the same problem. Nobody ever does this without putting 5 screws above the fracture and 5 screws below the fracture. Nobody with any experience does that. That's admissible, even under 404B, because it goes to something other than propensity.
And what would that be?
Experience.
Okay.
And by the way, the cases that I've read that come out of this court in the criminal area seem to be quite liberal in interpreting the exceptions to 404B, and I should think that one would work. Can I, is it okay if I move on?
I'm good.
Because by far the most important issue in this case is the 2169 issue. Now, MCL 600.2169 is the only statute that I know of that the first time it came to this court on a substantive basis, the second time it ever got to this court because of the Dougal case was first, but the first time this statute got addressed by this court on a substantive basis, this court could not even agree on what opinion got 4 votes. This is a statute which is incredibly...
I think there were 2 that got 4 votes.
It is incredibly badly written. It is, in my opinion, badly conceived even before it was written. But we have a statute which is written in an incredibly confusing way, despite what may look like brevity. And the defendant's position in this case is make it worse, because that's what the defendant is asking for in this case. And there's no reason to make this statute worse than it already is. There's no reason to add what is going to be an incredible layer of confusion to this statute, which is already so difficult to apply in a real-world setting. And let me comment one thing on what Mr. Cook has said. Mr. Cook, I believe in response to Justice Bernstein's question, suggested that there is a reason to have this board certification as of the date of trial, and that's to show that the person is still in the game, he's still involved. Well, that argument makes no sense, it seems to me, in light of 2912A. And that's a point that the Court of Appeals quite properly made in this case. I didn't, but they did. And that is, under the statute 2912A, standard of care testimony is only based on the medical science as of the date of the malpractice. And remember, 2169 only applies to standard of care testimony. So to suggest that there's some purpose behind this in having somebody still in the game, somebody who still got a board certification at the time of trial, is wrong in light of the fact that 2912A specifically states that it is medical science, the medical arts, as of the date of the malpractice that controls standard of care. Now, the defendant's position in this case is that you take the second sentence of 2169(1)A, you see the word is, and it automatically means the present tense. You cannot make it into the past tense. It just can't happen. That's what they say. One need only go one sentence before to see that that isn't accurate. Because for whatever reason, the Michigan legislature, when it passed 2169(1)A, it began with the first sentence that clearly is in the past, because it identifies the date of the malpractice, but it uses a present tense verb, specializes. Now,
your argument is since they suspended the rules of grammar for the first sentence, they should be suspended for the second sentence as well?
That is exactly correct. What it shows is that he can't be correct, that it across the board is means is must be interpreted as a present tense. In fact, I went back and read the Woodard case, and Justice Markman, in your opinion, you actually put brackets. You changed the word specializes to specialized in your Woodard opinion. The fact is that it is in the present tense. Their whole position is it has to be the present tense. You can't identify a past time period by using the present tense, but the prior sentence shows otherwise. I made reference in my brief to the Shinholster decision of this court, because Shinholster did in fact involve another present tense verb. And what the court did in the Shinholster case is Shinholster, by the way, is the cap on non-economic damages. And it had to do with whether somebody had the mental incompetency to claim the higher cap. And it does, in fact, use a present tense verb, has, I believe, has mental incapacity. This court was faced with the argument that the word has to be as of the time of trial, means that the plaintiff must have that. And we faced exactly the same problem in Shinholster that we face here, and that is the strange result which occurs when somebody dies on the courthouse steps, as I'm going to talk about in a little bit. The fact is that this court ruled in Shinholster that the word has, when you read the statute as a whole, the word has can, in fact, be a time period that is other than the present tense, other than the time of trial, or in that case, the time of judgment. And the decision in Shinholster made reference to a point of reference. That is, the statute itself has a point of reference in terms of its timing. And that is the point that I'm trying to make here, because the fact is that the point of reference of this statute is, in fact, the date of the malpractice. That is reflected, obviously, in the first sentence, as specializes as of the time of the malpractice. Now, I want to talk, because I think it's very important, I want to talk about the implications of the defendant's argument in this case. Because if is means is, the implications of that are dramatic in the legal and medical malpractice setting. And that's because this statute uses the word is to describe the status of two different parties. One is obviously the defendant, and the other one is the party involved, or the person involved in this, Dr. Viviano, the experts. Because both of them would be subject to this present tense verb, which means their position is simply that because Dr. Viviano's status changed over the course, his board certification, which was there at the time of the a malpractice and wasn't there at the time he would have testified at trial, that change of status changes his qualification. Exactly the same thing would have to be true of the defendant, because it uses the word is in both the first 1A and 1B to describe the defendant. Now, the implications of that are really dramatic because, as I hope you've grasped by now, the fact is that any change in the status of the defendant would mean that the necessity or the qualifications of an expert would have to change. Because if a defendant retired, if a defendant
Lost his certification,
or if a defendant, more importantly for my purposes, died. If a defendant dies and the is means is, then in point of fact, and is means the date of trial, that defendant is no longer a specialist. And that defendant is no longer board certified if he was before. And that means every part of 2169, A and B, are gone. They're gone. And why are they gone? Not because the malpractice changed, not because something different happened that created the cause of action, but because the defendant died, something totally adventitious.
Why is it much more likely that the defendant would lose his certification?
Well,
the same problem is introduced, right?
That's
If
correct.
at the time of trial the defendant is no longer board certified,
That's correct.
then the opposing physician expert need not be board certified under the construction of the defendant, correct?
That's correct. Now, mind you, if board certification, if he's no longer specializing, then the first sentence would not apply either. So if he retired, a doctor or she retired, the fact is that you would have a situation in which neither the first nor the second sentence would apply, in which case the qualifications of the expert would change. Now, that raises another serious problem.
I'm sorry, I don't follow. So,
Retirement.
yes, but the first sentence gives us a time frame, at the time of the occurrence. So,
No, you're missing the first is in that sentence is what I'm talking about.
yes, is a specialist.
Is a
Specializes at the
specialist.
time of the occurrence.
That's right.
Oh, I see. So you're saying that even though there's a time frame in the first sentence, at the time of the occurrence, we must read
If is means is,
to mean
if
present
he's
tense
right,
in both sentences. Well, why?
why? Because that's what he's saying is means.
Well, he's saying it means it in the second sentence, but I think he's saying it means it in the second sentence because there's no link back to the time of the occurrence in the second sentence.
Okay, but the fact is, the first sentence begins, if the party against whom or on whose behalf the testimony is offered is a specialist. Okay, and the
Yeah,
next
I
clause,
understand that.
the next clause is not referring to that person. The next clause is referring to the expert. Okay, you're going back to the introduction. So that first clause is independent of what follows, because the comma what follows from the comma is in fact a description of the expert. The expert specializes. You understand?
got it.
Yeah. Okay.
So
So here's another point that is important in all of this for real practitioners, okay? The fact is that if they're right, and if you decide this case, there are no pretrial motions that could ever be made challenging an expert on the basis of 2169.
Oh, that's not, I mean, we just had that colloquy.
Yes?
I move to dismiss because Dr. Viviano is not currently board certified.
Yes?
And unless the plaintiff then comes back and says, he's not, but I guarantee, here's his affidavit, he will be board certified by, then that's the only way you defeat it, isn't it?
And what's the remedy that the trial court imposes in that situation? Can he bar him? No.
No,
He can't bar him.
if the plaintiff comes back with Dr. Viviano's affidavit saying, I have done the process and I will be board certified by the time of the scheduled trial, then the motion is defeated.
The motion is premature. Your motion is premature. And the reason it's
it isn't-
premature
it
is
is not-
because trial hasn't started.
It is not premature if there is no opposing evidence that he will be board certified at the time of trial?
No, there's no evidence that Dr. Crocker will be alive at the time of trial. There's no evidence that Dr. Crocker won't have retired at the time of trial. There's no evidence that Dr. Crocker won't have lost his board certification before trial. It's all premature, all of it.
It's all speculative. We could speculate. That'd be fun.
Pardon?
We could speculate.
Yes, you could speculate, you certainly could. But the fact is, you could issue an advisory opinion. If trial starts and nothing has changed, then in fact, Dr. Viviano is stricken. That's what you could do. Okay? But that, as you know, that's how things are usually dealt with in the medical malpractice area. That is, there are pretrial motions, and this stuff gets settled pretrial. But if they're right, things can change. Things can change between now and trial. And in fact, in his deposition, for what it's worth, Dr. Viviano testified, I'm going to go back and get my board certification. Apparently Mr. Cook has checked and he hasn't done it yet. But if he does, and he's qualified, then he's qualified. So it's not until trial starts. I mean, that's a pretty bizarre result, it seems to me. The other really bizarre result that comes from this is outside of the two references directly in the statute, that is, A, the reference to the specialization of the expert at the time of the malpractice, and in B, the one-year rule with respect to the majority of practice. Other than that, the malpractice is irrelevant. Nothing about the malpractice matters to the qualifications here. Nothing. Woodard is wrong. That's what results from this, if this court adopts this argument. Because Woodard said, as its very core, and it's the core part of the Woodard opinion I don't disagree with, the fact is what you said in Woodard was that we look to the malpractice, we look to find what was the most significant, the most applicable standard of care. But you look to the malpractice. That was the whole essence of the Woodard opinion. Wrong. It's wrong. If he's right, Woodard's wrong. Why? Because the malpractice means nothing. It's what the defendant is doing at the time of trial. The entire focus, if the defendant changes specialties between the time of the malpractice, he's practicing as a, I don't know, in a hospital, moonlighting in a hospital, and becomes, between the time of the malpractice and the date of the trial, he becomes a specialist in OBGYN. Okay? The malpractice is irrelevant because it's what he is, according to them. It's what he is at the time of trial. Woodard's wrong. That's the bottom line here. The fact is, it means nothing outside of these two direct references in the statute to the date of the malpractice. The fact is, the malpractice itself and the date is completely irrelevant. That's what we would be looking to. You would be taking a statute that is poorly conceived and poorly written and making it worse, and making it incredibly impractical for real practitioners. When I wrote my brief in this case, until the last draft, I had a concluding line that no thinking person on the plaintiff or the defense side of the medical malpractice and medical malpractice, no thinking person could be rooting for Dr. Crocker in this case. Nobody. Now, I got the Michigan State Medical Society amicus brief, and I'll have to amend my statement. No thinking person on the plaintiff or the defense side should be rooting for Dr. Crocker in this case.
I'm sure they appreciate your solicitude.
I'm sorry, I didn't hear you.
I'm sure they appreciate your solicitude and condescension.
Do you have any questions?
Thank you very much. I do have a question for you. It appears to me that opposing counsel's made a pretty compelling argument that your construction of this case unmoors everything and makes the temporal status of the defendant and the opposing plaintiff expert makes all of this quite unsettled and silly, particularly in light of the fact that the standard of care, the burden of proof in this statute, 2912A, says the plaintiff has the burden of proving that in light of the state of the art existing at the time of the alleged malpractice, etc. The context is a malpractice, isn't it? The whole force of this is to create rules that align the combatant experts with the malpractice. Your theory unmoors that as the core and places the temporal significance on the status of the parties unrelated to the time of the malpractice. Isn't that accurate?
I don't think it does for two reasons.
Okay.
The first is that the specialization requirement is doubtlessly, beyond question, rooted to the time of the malpractice.
But nothing else is.
Right. That's significant because, and this is the second part.
Wait a minute. Let me just ask the question. Only the specialty is rooted to the malpractice. Everything else is irrelevant to the malpractice?
My point on that is that the board certification does not affect the standard of care, so it does not need to be rooted to the time of malpractice.
Wait a minute, the board certification
does not affect the standard of care. The standard for malpractice
Why do you think the legislature went to the trouble of having the plaintiff match its experts' certification up with the defendant doctors? What would be the purpose, do you think?
To make an apples-to-apples comparison of the people who are giving testimony to the jury.
On what issues?
So it's like a status thing?
Yes. Much like, and I get back to the point of having a medical license, it is showing this jury that this is somebody who has put in the time and dedicated themselves to the practice of medicine and taken this additional step, much like the defendant has, and they can then compare apples to apples.
Wait a minute. Isn't it more likely that they wanted to have equally sophisticated people on both sides of the V testifying about this malpractice?
Yes, that's my point. But in terms of,
you can be a general practitioner and you're subject to one standard, and if you're a specialist, you're subject to a different one. And if you're board certified, maybe the issues are you're expected to have even more competency.
A board certified specialist is held to no higher standard than a specialist. That's under the court rules. It's under the standard jury instruction for malpractice. You instruct the jury that it's a person of ordinary learning, skill, and judgment in that specialty. So it's judged solely based on the specialty, not having an additional level of education. And the point we made in our brief, it would be like saying a doctor from University of Michigan is held to a higher standard. He's not. He's held to an ordinary learning, skill, and judgment standard for that specialty. The board certification doesn't impact that.
I'm interested in the interplay between the statute at issue here, 2169, and the other relevant statute, 2912D. Under 2912D, a plaintiff is required to file with his complaint an affidavit of merit signed by the expert who the plaintiff's attorney reasonably believes meets the requirement of that statute. If the board certification requirement of 2169(1)A is interpreted only to apply at the time of trial, then the plaintiff or his attorney at the time of the 2912B filing would have to possess a reasonable belief focused upon some future point. His argument would have to be pure speculation that at the time of trial there'd be a matching of the board certifications. And in fact, the expert at the time that the complaint itself is filed under 2912B would not have to be certified, regardless of whether the defendant was board certified at that very time. Isn't that all kind of anomalous when you try to look at 2912B and 2169 together?
I think the reasonable
It's kind of a queer obligation you're imposing upon the attorney at the time of the filing of the complaint to speculate about what the relationship between the expert and the defendant might be a year from that time.
I think the reasonable belief language signals a lack of assurance that has to be acknowledged, and the legislature did acknowledge at the filing stage of the complaint. If a doctor is
But don't you
board
think that reasonable belief language is focused upon the uncertainty of whether or not they match at that time, as opposed to whether or not they're going to match a year from that time?
Well, if, for example, if the doctor has board certification, I think you can reasonably believe that you're going to need a board-certified physician to file that affidavit. If he's not, I think you can reasonably believe that you don't need a board-certified at that time. And I think, so there's a lack of assurance. It may change later on, sure. Much like you may find out that the doctor is actually specializing in something different. So we allow that wiggle room with a reasonable belief.
But it's not just the speculation, it's also the fact that they would not have to match at the time of the filing of the complaint.
With a reason, if there's a reasonable belief for why they don't match. Yeah.
No, they would not have to match at the time because it's only the trial that's relevant under your interpretation.
No, you'd have to have a reasonable belief to explain why they don't need to match. If the doctor has a board certification, there's nothing to suggest that he's going to lose his board certification. I think it's a tough sell for a plaintiff
No,
to
but
come in
there's
and say
no
that.
obligation on the part of the expert to share that board certification because the only time at which the initial filing has to match up the two would be in terms of the trial.
And if the plaintiff can show that his expert, he anticipates will have that board certification, then I think there's a reasonable belief for filing an affidavit by a non-board
But
certified
you're
expert.
overlooking my question.
I'm sorry.
Is it in fact the case that at the time of the filing of the complaint, there would be no need on the part of the plaintiff to demonstrate any matching between his expert and the defendant in terms of board certification?
I think it goes a step too far to say no need.
Thank you.
Thank you.
Case is submitted.